So my name is Gary Berger. I'm at Berger Law. This is Mike Flannery with Cuneo Gilbert and LaDuca, and we appreciate you coming. I'm a plaintiff's lawyer, been doing this for 25 years. Mike's a class action lawyer, has been doing this 26 years.
That's about right.
We can tell you how great, Mike's a great lawyer, does his class action stuff all over the country. He's better at it than me, so he's going to do the class action speech. We may change the order a little bit from what we said. We're going to jump right in on experts. Thanks, Rodney. We're going to jump right in on experts, and we're going to keep them coming as we go along. By the time we're through a lot more of this, you guys will all have a copy. You won't need anything. You'll keep up with us. So I'm not going to tell you how much more great either of us are other than that. There's our introductions. Mike is going to do the class action. We're going to do the expert stuff. Mike's going to do the class action talk because he's wildly successful at it and more successful than me at it. And then I'm going to follow up with liens. So let's jump right in with experts. So with the passage of House Bill 153, our expert statute in Missouri has changed. We're going from a Fry standard to a Daubert standard for experts. We have two presentations in the materials on experts. I did one and Mike did one. Mike has more experience dealing with Daubert than I, but we all deal with experts. I've taken a lot of expert depots over the years. So what this bill has done is effective August 28th of this year, the expert statute 490.065 is changed. The entire thing is repealed, and there's an entirely new one put in that is set out in my material. I have the old expert rule in point 2 of my expert paper called New Expert Rules under House Bill 153 and Other Expert Tips. I have the new full House Bill 153, which supplants the old statute. And then I have Federal Rule 702, what it's based on. So basically, our old Fry standard about whether or not it would aid the jury is gone, and this much more robust, much more stringent requirement of Daubert has been put into place. And it's different. It's not exactly like Federal Rule Evidence 702. It's got some other parts to it. For instance, you don't need an expert to talk about the value of your farm property, right? But other than that, I mean, it's going to deal with that. You still can have an expert talk about the ultimate issue in the case, but your experts have to rely on peer-reviewed material, theories that are commonly accepted in their area. They have to have adequate data to review, and there can be a threshold determination by the judge about whether or not they're going to be able to testify in trial and in front of a jury. So there's a lot of things that come with this. I think that our judges are going to be thinking more Fry and how they've done it for 20 years than applying Daubert. So I think over time, in practicality, judges are still going to think Fry, but over time, they're going to do more of the Daubert stuff as we go along. Please come in and grab a seat wherever you'd like. And so that's just going to happen. So 38 states, 39 states now use Daubert. And when Daubert comes in, studies have shown that plaintiffs' cases get constricted. Their experts get struck 92%. 90% of the judgments and rulings are against plaintiffs trying to bring those cases. But what it does is Daubert act as a gatekeeping device to keep out junk science and keep out non-thoroughly vetted theories. And so that's generally where we're going. So after August 28th, when you try a case, your experts are going to be, hey, Carrie.
How are you?
Good. Your experts are going to be subject to Daubert, and you're going to have to be ready for that. And Mike and I would like to talk to you about some different things. We have a lot of ideas about it, about how it's been done before, how it's going to apply practically, and whatnot. And I put in a lot of other expert points to kind of throwaways or kind of additional stuff. What are your thoughts on Daubert, Michael?
Yeah. So first of all, a lot of you, well, you may not know me because I don't do as much state court cases as Gary does, and a lot of my practice is around the country. I started out in Washington, D.C., first as a defense guy, then a plaintiff's guy, for 3 years. Then I moved to San Diego to a big plaintiffs firm that did almost entirely class actions. And then I moved here in 2000 and been doing class actions, first at Carigani and Lowe. Now I'm with this firm, Cuneo, Gilbert, and LaDuca, which is based in D.C., but I'm here in St. Louis. So a lot of my Daubert experience comes from federal court class action cases. I just did a hearing in the Northern District of Illinois in front of Judge Amy St. Eve on April 17th. It was a Daubert hearing. And my witness was the guy who she was having the Daubert question about. So the stuff I'm going to talk to you about, I think, is just sort of very intensely practical stuff about if you're going to have a Daubert hearing, this is what you need to pay attention to. And also, again, with the untested sort of introduction of Daubert in Missouri, it's not that case in the federal court. If you're in federal court, it's really, 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 really well tested. And the first thing that's going to happen is you need to have, and will almost certainly have had, a report that you prepared and your expert prepared, right? And I think it's really important to understand that when you're in court and you're in a Daubert hearing, you are defending your expert's report. That's what you're there to do. You're not there even to tell or get the judge to convince that your expert is right or that you're going to win, honestly. That's nice, and if you want to build that in because you're looking ahead to the jury trial, great. But that's not the function of the Daubert hearing. The function of the Daubert hearing is, the judge is looking at 4 prongs. Is your expert qualified? Has your expert relied on sufficient information? Does your expert's opinion come from reliable principles and methodologies? And is it relevant to the case? Does the opinions that your expert has given flow and flow from these really well-tested and reliable principles? And if you are getting those points across in the hearing through your testimony of your expert, then you're probably going to be fine. What I found in looking at the case law that the defendant cited against my guy, oftentimes it seemed to me that what was excluded, the reason your Daubert expert witness does not survive, is because they really have done almost nothing. They submitted a bare bones report. They didn't look at information that was obviously readily available to them. Testimony, in some cases, there was one case that the defendant cited against me. By the way, it's a case against Whirlpool. It has to do with in-wall ovens. We allege that they're defective because if you run the self-clean function, they shut down and become unusable, and we say that's a defect. Whirlpool tends to disagree with that. And so the point of this was, whether or not my expert would be allowed to testify about the defect itself. And so, what you need to pay attention to in those moments, it seems to me, is bolstering. First of all, we stipulated that the witness was qualified, and that may happen. It's something you want to think about. In the materials, you have Judge Amy St. Eve's standing order. And in that order, which you should check out if your judge has one, she's going to tell you, and that judge is going to tell you whether you can stipulate to certain things, take certain things off the table. And in this case, we stipulated that my expert was a qualified mechanical engineer, so he could talk about the things I was going to put him on the stand to talk about. What they took issue with was whether his opinions took unnecessary leaps from particular facts to particular conclusions, whether he had relied on sufficient facts, and whether ultimately his opinions were relevant to the entire issue that we're trying to determine. So, in those moments, and what happened in that hearing was all about the report that my expert had written and what I was going to do to defend that report. There's one other thing that's in the set of materials you should have. If not, I will pass out the
checklist.
The checklist.
I just told Rodney's bringing it down.
Okay. Here's a few of them.
So, and I interrupt you. Some of you guys have the big volume things. They're being copied now. They're going to break in about 10 minutes. You all will have a copy if you didn't have a copy already.
But one thing I want to emphasize when you look at this checklist is And again, this is really, it may become, the case in Missouri. It's certainly true in federal court. You need to be thinking about, in terms of Daubert, the standards from the moment you first talk to your expert witness. So if you are talking about the 4 prongs that the judge is looking at, or things that are being considered at the Daubert hearing, like in the hour before the Daubert hearing, that's not good. You need to be, in your first conversation with your expert, talking about what Daubert stands for, what the expert needs to be thinking about. And this is true whether your expert is really experienced or not. Okay? Some of them, a lot of these guys or gals, they get it. They understand what the judge is going to be looking at the end of the day. So they know what the steps are to take to get that report so it looks like what the judge is going to want to see and let the jury hear about. And if you are not doing that at the outset, then I think you're putting yourself at risk at the hearing itself. So that's the checklist, and you should look at that real carefully.
We're going to pass that along too. It's a great checklist. So, and the 4-prong, thank you, Mike. The 4 prongs that we're talking about are from Federal Rule Evidence 702. They're codified in Missouri under subparagraph 2 of the new statute. But when you have an expert come in and testify, you don't want to put out an expert that's not going to comply with that standard anyway, because the jury is going to see through it in a way too, right? So even though we're changing from Fry to Daubert, in practicality of what you're trying to do and how you're going to win your case, maybe it shouldn't change that case that much. But what you want to do is, when your expert's taking a position on something, whether it's a treater talking about medical issues, a mechanical engineer talking about product defects, a vocational person talking about wage loss, an economist, when they're talking about the standards and what they're using, they ought to be going back to 20-year-old principles of their profession that are well established. When I was in grad school, they taught me such and such and so, and I'm taking that old, well-accepted rule in science, and I'm applying it to the facts and circumstances of this case. Thanks for coming, Jim. So you want to do that. So I always say when I have an expert, I want them to say, this is an old rule. This is Archimedes. This is something that's well established. I'm applying it here. So you have a clear, peer-reviewed issue. And then the question is, what materials are you giving your client? You want to get your expert. You want to give them everything. You want them to have reviewed it. You don't want to meet the expert an hour before and say, now, where'd that depo go that you gave me? And then you want to make sure that the principles they're proposing here, the testimony they're giving, you're not pushing the envelope. Clearly reviewed, not stuff that is going to be challenged. Hey, thanks, Rodney. Do you mind going around, Rodney, and passing one of those out to everybody here? Thank you. So you want to do that anyway, but that's the concern that you have about Daubert. Now, with Daubert, there's going to be more of a gatekeeping with the judge in what they're going to let you testify to or not. That's the hearing that Mike was referencing last week. Appended to my material is a 30-page order by Judge Shaw from last year in a products case that I tried last year, where there were a number of experts. There's a statistician expert from GM, the defendant. There's some other mechanical engineers experts, and they sit there and he goes through his analysis. I have all the briefing. I didn't want to put it in the material. It's already too thick. We're already delaying getting it to you anyway from the copy place. But these issues, and Mike can address this too, is sometimes you got to make sure that you don't get a Pyrrhic victory in a Daubert hearing. You don't want to say, yeah, your expert can come in, but he can testify about ABC, but he can't testify about D through S, because that may kill your case. It may cut you a case. Med-mal cases, half the battle or more than half the battle in a med-mal case is causation anyway. Yeah, you can get a breach of standard of care, but what did it cause? So you don't want to lose the causation issue. So you want to make sure that you're going to win all those issues, and that's where I think the Daubert stuff kind of dovetails with a motion to eliminate. So if a judge, and these are all going to be, in practicality, I don't want to skip around too much, but we got to think procedurally, how is this going to happen in Missouri? We don't have the same rule of civil procedure like we do in federal court about disclosing 4 years of testimony, written report. We don't have that in Missouri. We may with this new expert change, but we don't have that now. So it's going to change your pretrial conferences. It's going to change the way you do expert depots. You got to look forward, just like Mike's saying, you got to be thinking ahead of time. You got to be thinking ahead about these Daubert challenges. And whether or not you've done your homework and you're able to withstand those. We had a guy, we did this seminar this morning too, because we were trying to do a cozier atmosphere here today. He took the depo already, but the case is going to be tried after August 28th. Our great associate Joel was doing some work for me, looking this really undecided about whether this is, the changes used to be if it was after August, if your case is filed up before August 28th, you don't get that cap or that kind of stuff. Here, this is a procedural change. You're changing the statute. There ain't no old statute to go back to. It's completely supplanted. So I frankly think that cases tried after August 28th are going to have this standard. So you got to think about this as we go on. But So this is going to mesh with the motions in limine. So if be ready for issues to be parsed out, and you want to be able to address all issues. Not only do you want your treater to testify about how your client was injured and the treatment he did, but you got to talk about causation, and you got to talk about what the effect of the degenerative back condition. Well, how did that affect your guy? And you got to think about future medical and how is that going to come in? And you got to think about how is the doctor going to testify about medical bills? Is he an expert in that too? Many are, many aren't. I don't know if you've done treater, and we can go on and on about this. Before DEC, we used to have all these depositions on the validity of medical bills, what their worth are, what the foundation for authenticity and all that. And so many treaters don't know that. So many do. You'd be surprised. Have a conversation with the treater before. You say, I'm going to have you testify about bills. And they say, cool. And you ask them, they say, well, they were on such and such committee from SLU Hospital, and they know everything about bills, or they have staff every year compares the Medicaid rate charge, and they do 150%. When you're a little bit, because you get that objection when you start talking about bills, and they say objection, foundation, and then you go, well, let's talk about foundation, and it turns out that the doctor knows a lot about it, which is great. But sometimes there's also qualifications for these folks. What about if you want to put on a physical therapist to testify? Are they going to be able to do it? So there's a lot of these questions, and we can talk more about them and take your questions about what your concerns were. But I think thinking ahead and dovetailing on the issues with the case is important, both in setting them up and being prepared. Forewarned is forearmed.
Yeah, and I would I would take that as a jumping off point. I think so it seemed to me in the hearing I was doing, which again, it was a product defect case, and in your materials, in addition to Judge Shaw's opinion, there's an opinion by Judge St. Eve's colleague, Judge Dow, from the Fluid Master case. It's behind my set of materials. Really comprehensive, very long opinion. Goes through experts on both sides of that product defect case, and you get a really good flavor of how the judges approach this. But I think you need to remember a couple of things. I think going into it, I felt like I needed to remember this. First of all, this Daubert hearing it's not subject to the rules of evidence. It is subject to Rule 104A, but that specifically says that this kind of hearing, the judge is not bound except by privilege. So pretty much anything can come in if you have a legitimate way to get it in. And so that's important. You also need to remember this prong of, is it helpful to the jury? Remember, Daubert is focusing on relevance and reliability. A lot of the attacks that the defendants were making on my expert had to do with, I thought, reliability. Did he look at sufficient information? He didn't consider this information. But relevance was important too, and you need to be able to show that the testimony of your expert is helpful. So, to the trier of fact, not necessarily to the judge, but the judge has to see it. It would be helpful to the jury. In this case, I'm alleging that there's a defective built-in wall oven. Why? Because there's an overheat condition that causes the ovens to shut down when they run the self-clean function. How does that work? Well, if you pull a wall oven out, you can't necessarily see airflow. You don't necessarily see heat transfer. But those things are subject to engineering principles, right? And my guy's a mechanical engineer. So in the prep, I'm talking to him about bringing out concepts of fluid mechanics and heat transfer equations. And I did some engineering background as an undergrad, didn't get the degree, but I know that there's these principles out there of thermodynamic laws. And so, I'm emphasizing to my expert, listen, when you're on the stand, first of all, you're talking to the judge. You're not talking to anybody else. Nobody else in that room matters except her. She's the one that's the gatekeeper. You need to be talking to her, right? Basic sort of testimonial stuff. When I ask the question, you turn and talk to her. But we need to be able to show that what we're doing, what you did, is going to be helpful to the trier of fact. And so you need to bring out where the layperson who's sitting on the jury may not understand and emphasize how your expert's opinion can help that layperson decide the ultimate issue. Is the product effective, right? So, you're thinking about all these things as you're presenting the evidence. When I watched the defense guys get up and make their presentation, it was one defense guy. Ultimately somebody else did the summary, but he did a lot of sort of Perry Mason. It was sort of Perry Mason-esque flourishes. He had a giant poster board with all of the ovens and all the models from like 2002 to 2014, and he demanded that my expert be able to say, "Where, sir, are the models of the plaintiff's homes?" And my expert said, "I can't exactly tell you this very specific model and where it is on that chart, but I can tell you that all of those ovens had the same fundamental platform," right? And that's the right answer. Last point on this, as I said at the start, those attacks by the defense in that moment, and it's true, you need to remember your expert doesn't necessarily have to be right.
This is a good point. Can you explain to me what your argument to the judge was?
Yeah, my argument to the judge was, listen, what they want to say is that I can't prove the defect, but that's not the issue on admissibility. That's not the issue on a Daubert hearing. The issue on a Daubert hearing is admissibility, not the weight. In other words, I wouldn't say this at the hearing, but you could say, for sake of argument, let's say that they've got a better argument than I do. Let's say he's a better attorney than I am. His cross is better than my direct. He's going to win. That doesn't matter. That's not the issue at the Daubert hearing. The Daubert hearing is very, very narrowly focused on these prongs. Is the guy qualified? Has he relied on sufficient information? Is he relying on principles and methodologies that have been tested? And would it be helpful to the jury? If you get those points across, you're going to be successful. Your expert's going to be allowed to testify to the trier of fact. So you're not necessarily going to try and say, I'm right, there is a defect. That's in some ways irrelevant to the question of whether he gets to make his testimony to the jury.
And thanks, Mike. And it's, are they going to add information to the jury? That's part of what the threshold is. Is the expert going to have facts and knowledge and conclusions beyond the ken of the jury, and that will his testimony help the jury? And that's two of the questions that I literally ask an expert when I'm putting them on the stand, so that the jury knows. I have in the material too, and not to call it, now that everybody has it, I have basic outlines in 9 and 10 about how do you put on the expert. Here's what you do. Here's the order. Doctor questions in 10, the other experts in 9. 8 is practical tips. But now you guys will all be reading it and ignore me for a minute, which is perfect. But you need to think about that, especially with the tire standard. Do you need the expert? I have a case right now. We're producing him in a couple weeks. He did this report, and And I looked at the report. I said, well, you know what? Can't you add this, this, and this? And he said, didn't you take the depot of the highway? This is a big truck crash case. Didn't you take the depot of the highway patrol accident reconstruction who said all that stuff anyway? I was like, yeah, you're right. He said, well, I don't need to duplicate. I go, you're right, because you don't want to replow old already plowed ground with an expert. You don't want to double up on experts. It's you as a lawyer, like, oh man, I don't want to not make my case, and I'm going to double up on stuff. Well, you can have them going different ways. You can have them contradicting each other, so you have to be careful of that. The other thing is we still have this doctrine called sudden onset in Missouri. So if you're trying a case and you're sitting there going, well, they only went to a chiropractor, do I want to do that? There's an old lawyer named Jim Collins, and he used to try a million cases. He'd go up and he'd read the medical to the jury. They go to an ER or an urgent care, and then you get the medical. So you can get that in. There's a lot of cases on whether you can get it in. So you need to back up too and say, do I need an expert? Do I want an expert for this proposition? The other thing you had me thinking about too, and while we're talking, if you guys have questions, raise your hand and interrupt us. So we're here to answer your questions and focus in on what you need. But one of the things you sit here and go, and just kind of to step on Mike's period, there is, how is this practically going to happen? Because in federal court, you have the Rule 26 disclosure for experts is, here's the report, 4 years of testifying, you're ready to go for Daubert. We don't have that in Missouri. Now, we may get it now that we have a new statute, but we don't have that now. So what, it's going to happen in pre-hearings, and you're already going to have done your doctor's deposition. So you need to think about this before, is when you're preparing these doctors and doing their depositions, or your different experts, your life care or your mechanical engineer in a product liability case, you need to be able to anticipate that and think about that. You want to talk about this with the judge in case management conferences. Judge, how are we handling this? Typically, these are handled in motions eliminate to exclude the deposition testimony of blah, 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 or motions to exclude parts of these things. Sometimes people can do a motion to exclude opinions held by experts under Daubert. There's different ways to join the battle procedurally, but these are going to change the way case management conferences happen. It's not just 15 minutes. Do you have the jury instructions yet? No, Judge. I'll give them to you on the morning of trial. Okay. Do you have anything? Yeah. Here's a couple. Different case management conferences can be more robust than others. So you need to think about that. But as you're going through these depositions, I think it's going to change the way we do our doctor's depositions and our other depositions, because you're going to want to have your expert has to, as Mike already said, he's got to have the facts, he's got to have the standard that he's using, the rule of physics, the rule of medicine, what it is, and he has to have that supported. The way I always very often talk about experts is we sit there and say, there has to be a rule, a safety rule, a rule of medicine. Did you violate the standard of care that says do a sponge count? Don't look, always don't cut what you can't see. Do this kind of test. Put this in your differential diagnosis. Don't exclude it until you have a test to exclude it. Do repeat tests. Whatever the standard is, you establish that that's a safety rule. Why do you have that rule? It's there to protect patients. What is that rule? Well, it's been around for 20 years. Here's the article from 1990 that first set this out in this textbook of medicine, so you know the rule's old. Now you do all those because that's a peer-reviewed old rule, and so that gets you past that hurdle. And then you take them, and then you apply the facts of this case to that, and so. Those are the things you're going to want to do, and you need to do that in the deposition. So if the other side comes in and does the deposition of your doctor, but they didn't say that because they just wanted to hit some points, and you're going to call that doctor live, you are going to lose the Daubert hearing. After the other side's done examining your guy, you have to sit there and say, I know the other side went, here's some things I want to ask you, doctor. What did you review? what is your opinions in this case? Do you hold those opinions to a reasonable degree of medical certainty? Because there's some tricky defense lawyers they'll come and take your deposition of your client or your other people or your experts, and they'll just cherry pick what they want to get out so they can cross them later. But you've done nothing to establish your prima facie case of getting the prima facie case at the Daubert hearing of getting your guy in. And you don't want to have to. What are you going to bring your treating physician to a Daubert hearing? No. I mean, it's going to be hard enough to get him to testify, hard enough to get him to do a report. Speaking of which, the other issue is reports. I mean, does your treating physician have to do a report? In federal court, this is an issue, and we've cited some Eighth Circuit law in here. I was at a case management conference with a judge in federal court 2 weeks ago, and Carol Jackson said, treaters aren't experts, you don't need reports. I said, cool. I also had a case one time where I had to get I was brought into a case to try it, and I had to go ask for a continuance. I asked for a continuance at the end of an argument where I lost the argument with the judge, and she said all my treaters have to author reports. So what do you do about that? Is that going to be required? Because that's required under the Federal Rules of Civil Procedure, not under 702, but under the disclosure. And so there are some judges in the Eastern District of Missouri that require it, some don't. Obviously, for a mechanical engineer, some of these people you do, but kind of not so obvious, because remember in the Missouri expert disclosures are very loosey-goosey. It's just the subject matter of what they're going to testify. You don't have to give reports. Well, I think that may change now, okay? And you may want to preempt a Daubert challenge to your expert. You may want to preempt that. In this, this case that I have coming up, I knew this was coming. I asked my accident reconstruction expert to do a report when he didn't have to, just so we could get it out there, get it to the other side, and be on all fours on that. So think about whether you need to do an expert. Now with the treaters, I always say the medical records are the report. There it is right there. Or you can do things like, but then what if you're going to go give extra documents to your treater? Do you guys do that? Do you give extra, Carrie, you give documents, and Brett, you guys give documents to your treater? How do you handle it?
I haven't had that experience. So.
I didn't mean to put you on the spot. Here's what I do. So typically, when I go try one of these cases, and I'm going to get back to you in a minute too, Mike. I don't mean to keep talking, but let me just get through the treater stuff.
You're doing fine.
Yeah, thank you. I appreciate it. So if you need to put on a treater to show causation, what your client's damages are, to get in the medical bills, to talk about future pain and suffering, and to put a face on the treatment, right? And so, but if you have a guy treated with 5 different places, you don't go take 5 depots, PT, ER doctor. No, you want to go to the main orthopod that either did surgery on your client or didn't do surgery or whatever, said there needs to be a future surgery. What I typically do, I give my orthopod the records. Here's the ER records. Here's the chiro. Here's the PT. They look at it all. They can talk about it. And then if I use my business record affidavit, I get him in 7 days, give the notice 7 days before. I can read those records to the jury, but he's also seen that. Well, a lot of times the federal judges will say, and there's case law that says this, that if they're just going to talk about their own treatment, you don't need to do a report. But if they're going to go beyond that, you do. So it's interesting. So, and I think different judges are going to play this different ways. And that's why I said at the beginning, I think judges for a while are going to think Frye standard, but eventually they're going to go all the way to Daubert and insist on this stuff. So how do you do it? What I've done in federal court cases, there's a number of things you can do. If you had a client with a bunch of medical, you can hire a different doctor to come in and look at all the medical and testify. But what if you got a $20,000 auto case in St. Louis County? Are you going to go? No, you're not going to go do that. So what I would do is give the doctor the ER records, these other things, and then ask the doctor to write a letter. You can ask the doctor, Doc, can you write a letter on whether or not you think this is related, and et cetera, and they will do that. A lot of times they won't put in causation in their regular notes, so that may not be there. And then if you go take that depo, the other side can say they're sandbagging you. So you want to do that. I think you want to ask the doctor to write a letter. You want to give that to the opponent, and then there's a little bit more of your report. Now, there is no report requirement yet, but I expect that we're going to have some other disclosure, discovery, or civil procedure rules changed to accommodate this new statute. The other thing is how you handle. How you handle things in the depot. You want to talk about that, and with your doctor or your expert, you want to get it all out there on paper so you're not sandbagging anybody. The other thing is, two other ideas I would provide is if the other side objects on the basis of form or foundation. You know how they do that? And my trick always is, I always go to them, I say, what's your form objection? What's your foundation objection? And it's especially true now. Because what you want to say to them is say, your objection on form, are you really hiding a Daubert challenge? Because I need to know now, while I'm taking my video deposition of Dr. Blah, orthopedic guy, are you saying that he doesn't have the articles or the rule? Are you saying that he didn't review enough stuff? Are you saying that it's not peer reviewed? What are you saying? You got to tell me now so I can remedy that now so you can't sandbag me for later. And there's a lot of cases that say you have to reveal your form objection now. You can't let that happen. And I think that's even more important. But even in your direct exam of your doctor, you want to address that stuff from the outset. Doctor, is the idea behind, do you have experience that whiplash rear end collisions cause the type of neck injury in people? Yes. Have you read articles about that? Yeah, a lot. Have you treated patients that? Yeah, I've treated patients for 30 years about that. Are the symptoms of my client and what you found in Mr. Smith consistent with those articles and those other things you've seen in those patients? I do that anyway because I want the jury to think that this ain't the first time this rodeo's ever happened. Is that a metaphor?
It is.
Thank you. I want it to, and they need to know. They want the doctor to say, listen, I've been doing this for 30 years. Everybody gets the same injury. It ain't nothing new. This is consistent with it. So you kind of want to do that anyway. But you can't let these other lawyers sit on these form and foundation objections. You just turn to them and say, what's your form and foundation objection? You got to tell me, you say on the record, you got to tell me, because if we're going to have a Daubert hearing and you're going to say my guy didn't say blah, 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 I need to know now so I can do it. The other thing you do is when you're deposing the other, this can harm the defendant too. I have some materials, we have all kinds of stuff appended to this. What about the defense doctor who never saw your client? You have a great Daubert challenge against him. I got one of those in here. Because what basis do they have to come and testify about your client and pre-existing conditions if they never saw him? And they'll all say that the medical exam and the history is 80% of treatment anyway. So you have a real challenge to them under Daubert there. And the other thing you do is you always cross-examine the doctor on the basics, on the rules. Isn't it true? And you get whatever you can from the defense doctor, who's a scientist, and you'd be amazed at what they're going to admit. And then if they admit what the scientific methodology is, they admit that it's peer-reviewed and clear, they admit there's a ton of articles about it, you can get the defense expert to admit a lot of the Daubert prongs that you need to satisfy in your cross-examination of him. You'd be amazed because they're all scientists. They all went to medical school together before the one got more business from the work comp insurance company and the other guy, started doing surgeries on, plaintiffs. So they'll say, isn't it true that a rear end impact causes trauma to the neck and that can herniate a disc? And this is how it works, da-da-da. Isn't it true that someone can have a herniated disc in their neck that is asymptomatic for a long period of time and then becomes symptomatic with an injury? Isn't it true that you don't do surgery based on a herniated disc and an MRI? You only do a surgery because the symptoms are causing impairment to that person, either pain or inability to earn wages and blah, 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 blah. Doesn't that person shouldn't the client? You don't expect this guy to go around with a herniated disc in his back, limping and urinary incontinence. He needs that surgery to remedy him from that, right? Yes, it does. So there's a lot of things you can get that you're later going to need to have in a Daubert hearing that maybe you wouldn't get because you think, I'm just going to cross them at trial or I'm going to do this. Sometimes you got to do some of this ahead of time. So sorry for going on long. What ideas thoughts does that prompt in you, sir?
So, so what I'm thinking of as you're talking about that is you've really got the Daubert hearing, and I guess I alluded to this in the checklist. The Daubert hearing is not where you should be starting to think about these issues. You have at least three opportunities in advance of the Daubert hearing to actually try to make sure that you never get to the Daubert hearing, right? The report, Gary talked about it a little bit earlier, but it's really crucial. You need to be grappling with the issues along with the expert in the writing of that report. You just do. And the checklist alludes to it, but you need to be telling, and by the way, these communications are protected in federal court according to the new rule. They don't get although to the extent that you're telling him what to consider, the defense may argue that you're providing him facts that he relied on. That's an arguable point. But you need to be in there grappling and talking and massaging that report so it demonstrates, it says here, the overriding purpose, this is in the Fluid Master complaint, the overriding purpose of the Daubert inquiry is to scrutinize the proposed expert witness's testimony to determine whether it has, quote, the same level of intellectual rigor that characterizes the practice of an expert in the relevant field so as to be deemed reliable enough to present to a jury. That's the overarching principle. In that written report is your expert demonstrating that the intellectual rigor, in my case, needed to testify about a mechanical property or the operation of a self-cleaning function of an oven built into a wall. Is he demonstrating what a mechanical engineer examining that issue would do in writing? Second part is the deposition. You got to get your client ready to be able to meet the questioning that is essentially the preview of your Daubert hearing, right? I mean, some of this was played at my expert's deposition. They're going to do that. You got video depositions now. And Whirlpool's counsel did that. They played a couple clips and said, you said X, and why did you say X then, and why are you saying Y now? Your expert's got to be ready. Hopefully he testified well at the deposition, but if not, he's got to be able to testify why he said that and how he explains it now. So all of those things are really important. The other thing I think we need to remember is that the judge, and you can see it in this opinion, in Shaw's opinion, any of these opinions that you read, the judge has wide discretion. Let me state the obvious here. You need to know what your judge has written about Daubert issues. The judge I was in front of, Judge Amy St. Eve, really, really, really smart, well-respected jurist, has already written opinions about Daubert. I needed to know those. I've digested them before I ever started to prepare my guy. I needed to know how she intellectually thought about it, right? She has wide discretion, and any decision she does make, I'm waiting on pins and needles for her to make it, whatever decision she does make is reviewed by the Seventh Circuit on an abuse of discretion standard, okay? So I have another case in the Seventh Circuit in a different, it's in the district of Western District of Wisconsin, which, by the way, has no brief length local rule. This is true. The Seventh Circuit judge said, wait a minute, there's no local rule on lengths of brief? I'm like, no, there's not. It's crazy. The defendant in that case.
That worked for you or against you?
Both. I mean, they filed like a 104-page class cert brief. And we're like, how can they do that? And I was like, there's no local rule on brief length. So that case involves another product. It's a defective window case. And we had an expert in that case. Just so happens it's the firm that's on the other side of my Whirlpool Ovens case. He was working for us then. And the defendants they made an argument to the judge in that case in Wisconsin. She's a Jimmy Carter appointee. And they said he made a mistake. He made a mistake in his report. He got this fact wrong. And because he got that fact wrong, his entire opinion should be stricken. And she did it. Okay, she did it. Now, we are in the Seventh Circuit, and we're arguing, number one, he didn't get that fact wrong. Number two, his opinions, don't rise and fall, even if, assuming arguendo, you say he got that wrong, which he didn't. But even if he did, his whole opinion shouldn't be gone. And by the way, she didn't hold a hearing. We made all these arguments. We felt like we have a really good, strong argument. But here's the thing. At the Seventh Circuit, on an abuse of discretion standard, our path to victory is very narrow. There's a lot of ways. There's a lot. So if you lose at the Daubert hearing stage, you got an uphill fight, because the judge, assuming that judge has taken into consideration all the information that you provided and they provided, and reviewed the briefing, and even if they didn't or didn't hold a hearing or didn't, you got an uphill fight. So all of that goes back to me saying, you've got to, it's the John Wooden thing. Those who have failed to prepare are preparing to fail. You've got to get your witness ready. And it has to happen from the first time you identify the witness. You've got to talk to that witness. You got to start talking Daubert standards before they ever bill you $1 for the work that they're doing.
Thank you. So those hearings are going to happen at the pretrial. Now it's pretty clear, if you got a mechanical engineer, or you hire a voc rehab person, or you hire an economist, or you hire someone like that, you're going to work with them. A lot of those folks already have 4 years of testifying to know. They already know some of the things and they're used to this. But the challenge, I think, too, is going to come in on these treating physicians. And but you remember, you can go, I do this all the time, you can go pay these doctors, here, can I pay you for your time? I'm going to go sit down with you and talk to you about this case. And you go do it. You do it before their depot, way before their depot. You show up early for the depot, they see you for 10 minutes, and then you walk in the door. But I don't think you can do that anymore. I think you got to do more things. The other thing is, so you got to give them all the records, because just like he got a fact wrong, so they threw out the opinion. What about if the treater doesn't know about the other car crash 3 years before that the defense got with the medical records, and they're going to try to ambush you with it because they didn't produce it to you? And then you're, well, it could be that, and so you really got to know that. So go pay the $200 or $300 or $400. Go meet with the doctor before they do it. The other thing is, what about these? What about, if you can imagine the cross, doctor, have you reviewed any records on other potential causes of trauma? How many articles have you written about back? There's a lot of things. So there's a lot of articles out there that we do use about how the mechanics of whiplash and how it causes injury. And that's always in a car crash case. There's a lot of other things. So what you may need to do too, and I'm sure some of us in MATA and some other things, we circulate these articles and these things to help each other out. I think on the plaintiff side, we're going to have to do some more talking to make sure that we can send a packet. Hey, doc, here's 4 articles on whiplash and da-da-da. That way you know that your opinion's on all fours. You're going to be comfortable in the cross from the defendant, and we're going to satisfy Daubert. So that's going to be important. The other thing is, in terms of that, these treaters, those people will know instinctively about things, but they may not have the articles in their pocket ready to go. So even if it's a hired expert, even when they come in, they got to be able to say, yeah, I know this principle of physics because of this article. It's best exemplified from Smith's article in JAMA in 1990. They got to have these articles in pocket ready to go. Now, in a big case where the money's worth it, you can have that pediatric neurologist go do all that research and have that stuff. It's harder to do on the other side. You may have to do that research for them and provide that stuff for them. It's certainly cheaper for you to do than for other people to do. The other thing I do with treaters is and these opinions is I say, and I wrote this down listening to you, Mike, is I always ask are the types of opinions you're coming at here, causation, future medical, the mechanics of whether or not it's a disc herniation that's causing the problem versus some type of narrowing of the facet joint syndrome or some of these other things, spondylolysis or whatever, are you just rendering these opinions and doing this for this case, or you do it for all their cases? And every doctor is going to say, no, I practice this stuff all the time. This is my bread and butter. This is what I do. You happen to be asking me about it in this case, but I practice. It doesn't matter who's asking me the questions. My opinions are what they are. And that goes to what he said, is your opinions and the stuff you're talking about part of what you do in everyday practice, or is it just uniquely for this case? And you really want to show, and that's good to show the jury anyway, that we're not just putting on a dog and pony show to try to get money from this defendant. This is what this doctor does every day, and they've been doing it for this long, and they're trained to do it, and our facts fit this. You want to, if you ever have a smart defense lawyer, if they go depose your doctors and do that stuff, they will never say the word to a reasonable degree of medical certainty. You ever had that? Especially in Illinois, where you have discovery depositions. They'll go depose the whole thing. They'll get all the facts, and then they'll never say, I always write RDMC. And then you go and you try to use that depo. You can't, because they didn't get that foundation. So you always do the things, and I have a friend of mine who had an expert pass away on him, and then he went to trial and he couldn't use the depo because he didn't go back and ask the question. So when you get done with, you're paying for that expert deposition, or you're there, you travel there, you're paying for the court reporter, get the basics down to what are you going to need to prove this case? What are you going to need to have that expert do? And you really got to think about it ahead of time. You don't want to. They say when you get that case, when the client leaves the door, write your closing argument. I don't know if anybody's ever done that. But you do got to think in the future a little bit more than maybe you did before about what are the elements I got to prove, what do I got to do? And I mentioned before, so I have the doctor questions. I have literally what you need to do, take them through the order, what you need to do on getting that. And you got to know, if you're going to get in future medical, you got to know how to get it in. You got to know how to doctor's opinion in on causation, other things. Oh, and the other thing is, so what about when there's bad issues for you, like Mike was saying? And what we do is you want to disarm it goes both ways, the defense. You want to disarm and take the wind out of the sails out of the other side. So you go to the expert and you say things like, you know what? You want the expert to say in a professorial, not talk down at you type of way, you know what? We were worried in this case because our client had a back injury 10 years ago, and we wanted to know whether or not that condition was causing his symptoms now, or whether it was the car accident a year ago. And so we wanted to look at that, and we started, and then the doctor will say, yeah, I wanted to look at that. Not, what can happen is you don't want to deal with that head on, and you do your whole case, and then the other side crosses, well, what about this 2002 and then it's like a gotcha moment. You don't want to do that. You want to take the wind out of their sails. You want to do it. And you go to the jury, we wanted to know. We wanted to examine whether or not the damage, because we don't want to come in and request any damages that this defendant did not cause. And our client was injured on the job in 2002 and went through 2 years of treatment, blah, blah, blah. So we wanted to do it. And the doctor comes in and says, yeah, you gave me those records. I looked at them. And the way I saw it, he had this, that, or the other thing in 2002, had an MRI, bulging disc not herniated, went through 3 months of PT, and then they were asymptomatic for 12 years. And so I don't think And there's a lot of things you're going to do, especially, and so I think you need to handle those degenerative conditions or those other things like that. The other thing we do is, I got this from the idea from this great book called Exposing Deceptive Defense Practices, is when you're cross-examining the doctor, I say, there's a scientific principle in any science, whether it's a mechanical engineer or a doctor or anybody, that you start from a position of neutrality. You don't have a dog in the fight, and then you have a hypothesis, and then you use the evidence for and against that issue to try to verify the hypothesis or not. And doctors do it all the time with differential diagnosis and ruling out. Mechanical engineers do it all the time because you could have multiple causes to things. And, our jury instruction says cause or contribute to cause, which is always an important issue in these cases. But you want to do that, and you want to show that, and that's a great peer-reviewed methodology. What judge could assail that on a Daubert hearing? And you say, yeah, when I looked at this, I started from position neutrality, and I weighed for and against. And I think that when you have some of these defense doctors who they've never seen a plaintiff who was injured, and they come in and they do the same deal. They'll do a 10-minute IME, they'll look at the same records, and they write the same report. I think we can challenge them under Daubert for not using a methodology that's peer-reviewed and fair and objective. That ain't something that's only for litigation, this independent medical exam. So I think, maybe we get some traction with attacking those and having, Dr. X come in and say the same stuff he's been saying for 30 years in a case. It's not a neutral expert that's come in a peer-reviewed way. That's only for litigation.
The only thing I would add along the lines of, how can you sort of bolster your guy looking at the other guy? In my hearing, the issue again was, are the ovens defective? And under the prong of has your expert looked at sufficient information, we part of this was taking him through the scientific method, which is systematic observations, measurements, hypothesis, experimentation, and testing. And the testing that our guy did in this case was the exact same testing that the other expert had done. Okay, they both wrote about the same testing. And the testing was essentially to go into the homes of the named plaintiffs and run the self-clean function when they first got there. Both ovens blew. And then Whirlpool literally, with both experts present, retrofitted the ovens and they ran them again and they blew again, which I thought was a significant fact. So the question becomes, my point here is that as many times in that hearing as I could, I tried to make it clear that, and it's clear from the papers, but, the emphasis has to be, listen, if what my guy did was insufficient to show that there is a defect, query whether what that guy did could also be characterized as insufficient in disproving this or defending this. So I tried to bring that out as much as I could. And the last thing that I would say is that, again, under the heading of when your expert is up there, and I knew this was going to happen, and so it's something that I think, frankly, I think it could happen probably more often here in Missouri as it's getting new because judges aren't going to be familiar with this. I knew and was really confident that at some point in my direct, the judge was going to take over and start asking the questions, and she did. She's brilliant, and those questions gave me the real clear answer about what it was that she was struggling with, and in this particular case, it was, I don't think she was struggling. Clearly, we stipulated she's not struggling with the fact that my guy is qualified, and I don't think she was struggling with the fact that he relied on sufficient information. I think the prong, and I don't think she was even struggling that it would be helpful to the jury. I think the thing she was trying to get, or was getting hung up on, was, has he moved in a reliable way from his factual determinations to his ultimate conclusions? In other words, did he move reliably in a logical, scientific method way from fact A, fact B, fact C, hypothesis to conclusion? And what she asked me at the end of the hearing was, does your witness need to be able to explain the ultimate cause? In other words, not just the definition that the ovens are defective because when you run the self-clean function, they shut down, but does he have to be able to say it's exactly this piece of the oven that causes them to overheat? She was struggling with that. My argument to her was, no, he does not have to show that. Whirlpool itself couldn't figure that out for 10 years, and hundreds of millions of dollars in ex-engineers, they couldn't figure that out. That's why we've alleged that all these ovens are defective. So no, he can show that there's an overall defect. This is my argument. We'll see whether it wins or not. But he doesn't have to get down to the actual literal piece of the puzzle because they couldn't figure it out, and he shouldn't be hung with that. And we talked about some of the Seventh Circuit case law and how that affected it. So, what I think, again, that goes to the notion that in the Daubert hearing, it's the judge. It's the judge. It's the judge. This is a gatekeeping function. And yes, it's meant to get rid of junk science, but, and I think this may explain in some ways why some of the defense, it's at least at the start, it can be harder to win these, is you've got to come up with an expert who can really cogently and smartly take that gatekeeper through the entire theory of what they've looked at. Whether it's a treating physician or a mechanical engineer, you've got to get somebody that can articulate that in a way that the judge says, that's solid, that's based on good information, that's reliable, the jury's going to get to hear that.
Thanks, Mike. So, I think one of the reasons why we have this new law is the talc powder cases that the great lawyer Jim Onder's been so successful with. Those were all thrown out in New York. And then they have these huge verdicts in the city, and so that's the issue. But that's really going to impact all of us, especially in these different areas. A couple that just the nuts and bolts. Don't write your opinions. Don't write your experts' opinions for them. Don't send them a letter saying this, and this. Do you agree? Yeah. I think we all know that. You mentioned, you could, even though there's not any jurisprudence on this here, there's a ton of cases on Daubert. And so you're going to have similar issues. So when you're going to go argue these, we're going to go to federal law and the Eastern District probably more before to guide the state trial judges on this. So think about doing that. So there you go. So just a couple random stuff. So in the end of my presentation, I have examples of a lot of different things about how to get defendants to admit the basic propositions defense doctors like doctors shouldn't needlessly endanger their patients, and that's the standard of care. And you have several options to them to do stuff. So there's a lot of ways. Don't forget, I know I already said it, but don't forget to get the standard of care from the defendant. And whether that's deposing the designee of the shopping mall where your person slipped, the defense doctor in a med mal case, the defendant in an auto case. We do that when you go and depose the designee of Whirlpool, or GM, the case I did last year. You do the same things. You get them to and then in Daubert, they come in and say, well, what do you have for this? Well, they admit it. No one's disputing this is the standard, that Whirlpool has an obligation. I don't know how you say it, but Whirlpool has an obligation to manufacture ovens that don't needlessly fail, that don't needlessly endanger people, that don't do this, that. So do that from the defendants. Always ask the defendants' experts about money. I have examples about how to get them. If they testify a lot, I have some examples in there. I also have an example about how I caught the other side. You got to be careful on these disclosures and the opinions. I had the lawyer hand the doctor his disclosure in the depot on the fancy video camera that I have here, and my cross was, the lawyer wrote your opinions. He just handed them to you off camera. Isn't that true? Da 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 da. And we got a lot of hay with that.